started out in the beginning part of my closing argument was that, you know, you need to consider all of the case. Obviously, all of the evidence in this case, because it's an evidence, and consider it. But all of that is geared towards what happened on May 11, 2015. I ask you to focus on that day and not be distracted, because that's exactly what Mr. LaFay wants to do. He wants you to focus your attention away from Mr. Apperson. That's what he did for the last hour. And he wants you to start thinking about George Zimmerman. And he wants you to start thinking about George Zimmerman so much, and so much, and so much, and start hating George Zimmerman. And if you just do that, if you start thinking about George Zimmerman and start hating George Zimmerman, you just may forget about Mr. Apperson. And I ask you, please don't be distracted by that. Because that's exactly what he wants you to do. Completely forget about Mr. Apperson like he's an innocent bystander. Focus all your attention on him. Please don't do that. It's Mr. Apperson that's on trial. Mr. LaFay began with September 9th. Of course, this crime occurred on May 11th, but he wants you to start thinking about September 9th. And then Mr. LaFay starts talking about how on September 9th, Mr. Zimmerman harassed Mr. Apperson, and then he'll do it on May 11th. Well, you see, the problem with that argument is there's evidence that shows just the opposite. Once again, as much as Mr. LaFay tries to spin that video and the photographs, as much as he tries to do that, please look at that video. Please look at those photographs. Please focus your attention on May 11th. You consider all the evidence, of course, but it's all geared to focus on May 11th and look at that video. And like I said at the beginning part of my closing argument, play it at regular speed. I mean, you can slow it down if the computer and the juror has the ability to do that, but play it at the regular speed. And then compare the speed that Silver Infiniti is going to the other vehicles on the road. And you'll see that it zips by faster than all the other vehicles. Mr. LaFay makes the statement that Mr. Apperson is not a hothead. And that's a quote. Mr. Apperson is not a hothead. You fat motherfucker. That's not a hothead? That's what Mr. LaFay is arguing, and that's what he wants you to believe. You're at the U-turn. And the evidence is that it was Apperson that initiated it. You fat motherfucker, you owe me. I didn't press charges on you. That's what Mr. Zimmerman said. That's what Mr. Apperson said, he said, when Mr. Apperson testified. That's not a hothead. That's the argument that Mr. LaFay wants you to believe. Well, consider that. Consider that argument, that that's not a hothead, in the context of all the other arguments that Mr. LaFay made. Consider that. And then evaluate Mr. LaFay's argument. When he makes a statement such as that that's not a hothead. Mr. LaFay also makes the argument that I, the prosecutor, says that September 9th doesn't matter. Once again, kind of misconstruing what I said. I never said September 9th doesn't matter. I said it over and over and over again. You consider all of the evidence in the case. That's what I said. I said that repeatedly. I said it a moment ago. I said it in the first part of my closing argument. You consider all the evidence in the case. So yes, September 9th does matter. I never said it didn't, as Mr. LaFay says I said it. I never said it didn't. But once again, you consider that, all of that, in the context of what occurred and geared towards May 11th. Because that's the date this crime occurred, May 11th. Not September 9th, not September 11th. Mr. LaFay says that Mr. Apperson acted reasonably on May 11th. That's what his argument was. Well, consider that in the context of the two previous arguments I said that Mr. LaFay made. How he spun those. Well, maybe there's a little spinning on going right here, that he acted reasonably on May 11th. I'm going to give you a little friendly challenge right now. I challenge you to go back to that jury room and try to come up with something that Mr. Apperson did that was reasonable with regard to the encounter, which is what this case is about, the crime that occurred on May 11th. With regard to the encounter on Lake Mary Boulevard on May 11th, I challenge you to go back there and try to come up with something that he did that was reasonable, prudent, and cautious. He's the one that went after Mr. Zimmerman. He's the one that got behind him on the U-turn. He's the one who followed him after the U-turn was made. He's the one who grabbed his gun and in one motion shot, by his own admission, before there was any imminent threat. That's what he said. That's not what I said. And Mr. LaFay certainly wasn't going to point that out to you in his closing. That's what Mr. Apperson said, that there was no imminent threat when he pulled that gun. That's his testimony. And that's what the self-defense jury instruction tells you. That's the question in this case. At the time he pulled that gun and shot, was there an imminent threat of death or great bodily harm? And Mr. Apperson answered that question for you when he testified. That's what he said. I hope you have it in your notes. I hope all of you remember it. That's what he said. No imminent threat when he pulled that gun. And you know the problem that they have? The problem are the facts, the physical evidence. That's the problem they have. The video, you fat motherfucker, he followed him after he made the U-turn and he couldn't see through that window, and I'll talk about that in a couple of moments. Mr. LaFay went on for quite some time about Mr. Zimmerman's numerous inconsistencies, which of course is what he wants you to start focusing on. Terrorist? That's what he called Mr. Zimmerman, a terrorist. Well, you really need to start hating Mr. Zimmerman. You really need to start hating him. Because if you start doing that, you're going to stop thinking about Mr. Apperson. A terrorist, twisted, a liar, a serial liar, starting to hate Mr. Zimmerman. Because if you do, you're going to stop thinking about Mr. Apperson. September 9th, September 11th. The more the better. The more you hear about that, the more you start hating him. And the less you start thinking about Mr. Apperson. Samantha Scheibe, his ex-girlfriend, got to think about her. Got to think about her. Because if you think about her, you're going to stop thinking about Mr. Apperson. And then, of course, the big one that Mr. LaFay wants you to start thinking about, the big one, Trayvon Martin. Now you really hate him. Now you really hate Mr. Zimmerman. You don't remember Mr. Apperson at all. That's what he is doing, Mr. LaFay. Trying to distract your attention away from what this case is about. But anyway, what I was going to say is, Mr. LaFay talks about all the inconsistent statements that Mr. Apperson made. Well, you know what the biggest inconsistent statement made in this trial? Mr. Apperson's description of the event. The event that occurred on May 11th, 2015. The event that forms the basis of this case, the charge. The event that we're all here on. The event that I've repeatedly, probably ad nauseum by now to you, repeatedly implored you to focus on. That's the biggest inconsistency in this case. Because his description, you remember his description in that Lake Mary Police Department interview? How he's just casually driving down Lake Mary Boulevard, going eastbound, the wrong direction, and Mr. Zimmerman pulls right up to him, pulls a gun, I'm going to kill you, which is unbelievable in itself. Just casually driving. That's the biggest inconsistency. But Mr. LaFay's not going to talk about that. He sure wants to talk about Mr. Zimmerman. Keep on talking about Mr. Zimmerman. You'll forget about that inconsistency. Once again, Mr. LaFay makes the argument, well, the state asked you to find the defendant guilty because he called Mr. Zimmerman a fat motherfucker. Well, if you can't meet your opponent's argument, then you change your opponent's argument, and then you meet it. No, I never asked you to find Mr. Apperson guilty because he called Mr. Zimmerman a fat motherfucker. What I am asking you to do is to consider all the evidence in the case that shows on May 11th. And I'm not going to repeatedly go through it again because I've done it a few times already. All of the evidence in the case, the video, his admission that he pulled that gun before there was any imminent threat, all of that. The fact that you can't see through the window, you cannot see through that window. That's what I'm asking you to do. I'm not asking you to find Mr. Apperson guilty because he called Mr. Zimmerman a fat motherfucker. And then, of course, with absolutely no evidence to support it, none whatsoever, none, zero. Mr. LeFay makes the argument that at that U-turn, Mr. Zimmerman's now reaching for the gun, pulling out that Springfield and pulling back the hammer. But once again, another little friendly challenge. Go back there and see if there's any evidence of that. None whatsoever. But that's the argument that Mr. LeFay is making. None whatsoever. And you, as a jury, decide this case based upon the evidence and the law. And there's nothing, absolutely nothing, zero, to support what Mr. LeFay said, what was going on at the U-turn. Except the fact that Mr. Apperson called him a fat motherfucker. Waited a long time at the U-turn. Mr. LeFay makes that argument. He waited a long time at that U-turn. Well, what was going on at that U-turn is they were exchanging words. And that's what the evidence is. They were exchanging words. And there was an argument. There was an argument going on at that U-turn. And that is perfectly consistent with Mr. Apperson saying, this is it, I'm done with George Zimmerman, I've had enough of him. And just losing at that point. That's what the evidence supports, the going back and forth at that U-turn. And Mr. Apperson finally said, this is the straw that breaks the camel's back. I am done with it. And now I'm going to take care of it. Mr. LeFay made the argument, when talking about the reasonable doubt jury instruction, that the state has to prove beyond a reasonable doubt that George Zimmerman did not pick up the pistol or his gun. That's the argument that he made. No, that's not true. The state has to prove beyond a reasonable doubt that it's not self-defense. And there's a subtle but a big difference between the two, an important difference. Proving not picking up the gun is not the equivalent of it not being self-defense. The state has to prove beyond a reasonable doubt that Mr. Apperson did not act in self-defense. Not that George Zimmerman didn't pick up the pistol. And all the evidence that I talked about, and I'll try not to talk about it again, shows that it's not self-defense, including and especially Mr. Apperson's admission on the witness stand to you that there was no imminent threat when he picked up that gun. And if you're going to use deadly force, if you're going to point a gun at someone, and you're going to pull the trigger, the threat has to be imminent. Has to be imminent. If you're going to kill someone, there has to be an imminent threat to your life. And thank you, Mr. Apperson, because from his own words, his mouth on that witness stand, when he picked up that gun, there was no imminent threat. It's not self-defense. That's proving it beyond a reasonable doubt that it's not self-defense. I don't have to prove beyond a reasonable doubt that George Zimmerman didn't pick up a pistol. But once again, that's Mr. LeFay's argument. That's how he's shaping his argument. Consider that in the context of all the other arguments that Mr. LeFay is making. That's how he shades it. Little subtleties. Consider that, please, when you think about my argument and you think about Mr. LeFay's argument. And remember, please remember, during that interview with the Lakebury Police Department, he described it all in one motion. I picked the gun up and I shot. You can believe that. Mr. LaFay tells you to believe it. Mr. LaFay told you to believe what he said in his Lake Mirror Police Department interview. So you can believe that. And that is the truth. All in one move. So when he picked that gun up, that was the shot. No imminent threat. Because he had it with Mr. Zimmerman at that point. He had enough of him. Which doesn't justify, it doesn't justify what he did, but it explains what he did. And there is a difference between justification and explaining. It explains what he did. It doesn't justify it. It explains it. Once again, another one of Mr. LaFay's arguments, that the state's asking you to convict on the testimony of a serial liar. Well, you got to keep on thinking about George Zimmerman. Got to do that. Serial liar. Well, once again, I'm not asking you to convict on the testimony of Mr. Zimmerman. Not only on the testimony of Mr. Zimmerman. What I'm asking you to do is to look at the evidence that what happened on May 11th, which consists of, and I'm not going to go through all of it again, but especially and including Mr. Apperson's admission that there was no imminent threat when he pulled that gun. Hidden compartment. Sounds so sinister. But of course, it's associated with George Zimmerman, so Mr. LaFay has to call it a hidden compartment and argue that. And that's what Michelle Hernandez called it, the hidden compartment. Well, with all due respect to Detective Hernandez, if you look at the photographs, it's not a hidden compartment. There's letters and buttons there where you can, it's a console, it's a center console. But if you keep on hearing the word hidden, 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 well, you're going to think, man, George Zimmerman, what a sinister guy. He has a hidden compartment in his truck. Wow. Boy, we may start really hating him. It's a center console. Look at those photographs. It's part of the Honda Ridgeline. It's not a hidden compartment. But you got to hear that word. You got to hear the hidden compartment. Mr. LaFay points out that George Zimmerman didn't give a statement. And he tries to, Mr. LaFay tries to spin that as being so sinister. We didn't give a statement. Well, of course, that can only mean one thing. And he's trying to hide something. It's like a hidden compartment. And of course, if he's trying to hide something, you're going to start hating him more. It is perfectly reasonable. Please ask yourself, it is perfectly reasonable. Considering his experience, considering the previous legal entanglement, it is perfectly reasonable, having just gone through something like this, where the police are all around him, for him to say, I want to talk to my attorney. Because this guy, Apperson, may just be claiming I went after him. So I don't want to say a word until I talk to my attorney. It is perfectly understandable. It is perfectly reasonable. And please don't hold that against him because he wanted to talk to a lawyer first, given how serious this case is and given his background, his experience. And Mr. LaFay made the argument about a comment. by one of the witnesses about acting more like a suspect than a victim. Well, my recollection of that remark, and once again, that's Mr. Lefebvre's argument, you're acting more like a suspect than a victim. But once again, it's kind of shading it a little bit. Because my recollection of it was, the question was suspect or victim. So that argument, once again, the subtle shading that Mr. Lefebvre makes when he makes his argument to you. And there's a difference between the two. Between, on the one hand, you're more like a suspect than a victim, versus suspect or victim. That's what the testimony was, that Michelle Hernandez asked him, the testimony was suspect or victim, not more like a suspect than a victim. And there's a difference between the two. Mr. Lefebvre also makes the argument about how the photo is proof beyond, how this photo, I think he was referring to the arm, about the injury photo. This photo, once again, is the proof beyond a reasonable doubt. Well, once again, a mischaracterization of the argument, of my argument. But of course, you got to change your opponent's argument if you can't meet your opponent's argument. Change it, then you meet it. As I said over and over and over again, it's all the evidence in this case, not one particular piece of evidence. But the defense counsel keeps on making that argument, keeps on cherry-picking individual things, and then says that the prosecution wants you to find him guilty based upon only this. No, it's everything. It's all the evidence in this case. I'm not going to go through it again. But, including and especially, Mr. Apperson's admission on the witness stand, out of his mouth, that there was no imminent threat when he pulled that gun, which means it's not self-defense. Mr. Lefebvre asks, well, how could he know that there was no passenger in the car? Well, the answer, I think from the evidence, seems pretty obvious how he could know. It's when they had their encounter, probably an extended encounter, at the U-turn. When Mr. Zimmerman was angled to make his U-turn, and they had their exchange back and forth. That's how he knew. Because there was only Mr. Zimmerman in the car. Mr. Zimmerman's window was rolled down, and they were going back and forth. Mr. Lefebvre makes the argument, well, he pointed a gun. How could he know? He could obviously see through the window because he pointed a gun. Well, that argument assumes that he's telling the truth. You didn't see him point a gun. You know, look at the logic of that argument. That argument is asking you, the argument is saying, well, he said he saw him point a gun, so he must be telling the truth. That means he must be able to see through the window. Well, I think you got to ask yourself the question, first of all, did he see the gun? Because when Mr. Lefebvre makes that argument, he's assuming that Mr. Apperson's telling the truth. And Mr. Apperson told us that there was no imminent threat, so obviously he didn't see a gun. Mr. Lefebvre makes the argument started to make the argument that every witness who said, "You can't see in the car," and then stopped. And then started to talk about that sunblock that was on the windshield. Well, the witnesses after Officer Call, it appears from the photographs, saw that truck with that sunscreen, the sunblock on the windshield. But Mr. LaFay can't shake the testimony of John Call. And that's the reason why I implore you to consider Officer Call's testimony. Because it's like, it's like an experiment. When you do an experiment, you want to create the closest conditions that you can. And John Call is the experiment. Look at the surveillance video. Look at the counter at the bottom of the time. You'll see, I think it was approximately between 10 and 12 seconds after George Zimmerman and Matthew Apperson whizzed by going westbound. Look at that timer. I think about 12 seconds passes, and then you see Officer Call, luckily, fortuitously for Mr. Zimmerman and this case, go by. So it was about 12 seconds, 13 seconds. Maybe a second or two more, but look at the video and you'll see Officer Call just kind of going on down Lake Mary Boulevard westbound. So it was 10 to 15 seconds after Mr. Zimmerman and Matthew Apperson. So that means that Officer Call was literally 10 to 15 seconds behind them. It's the perfect experiment. The perfect experiment. The conditions were identical. The truck was in the same condition. The windows, the lighting.
Mr. Stone, can you start to wrap it up your
Yes,
2 hours?
The lighting. He's right there. He goes past it, he can see it, and he couldn't see in that truck. He couldn't see in that truck. And he was specifically looking for a deadly threat. And that's the reason why he backed off and took cover. That's the reason why Officer Call's testimony is critical when you ask yourself the question, could Mr. Apperson see into that truck? And the answer is no, he couldn't have. Mr. LaFay talked about the rear window. Well, this case isn't about the back window on that truck. It's about the side windows. So once again, don't be distracted. And the photograph, number 6. Mr. LaFay makes the argument that you can see through this, that there's an arm there. Well, go back there and see if you can. First of all, remember, the window was shattered. Okay? The window was shattered. And here's Michelle Hernandez's reflection. And you can't see through any other things on the other side of Lake Mary Boulevard. But Mr. LaFay is making the argument without absolutely no evidence whatsoever that this is another police officer standing on the other side of the truck. So therefore you can see into it. Well, if you could, then why can't you see other things beyond there? And if it's another police officer, you can't see really what that is. But they're wearing a gold bracelet and an orange. But Mr. LaFay argues this is an arm. Well, consider that argument in the context of his other arguments. Okay? Please do that. And then ask yourself, especially when you can't see anything beyond it, I'm almost finished, Your Honor. No duty to retreat? Mr. Levin made that argument? Well, he's wrong. Because there are exceptions to the stand your ground law. There are two exceptions to the stand your ground law where you do have a duty to retreat. Now, Mr. Levin is going to make that argument that you have to have a duty to retreat. The first exception is if you're the aggressor, you have a duty to retreat. The second exception is if you yourself are committing a crime and then you claim self-defense, you have a duty to retreat. So look at that jury instruction real close, and you'll see that there are two exceptions.
Characterization of the law.
Ladies and gentlemen, I will be reading the instructions to you. The copy of the instructions I will read will be going back to the jury room with you. What I read in those instructions you will see are the law.
I'll have one more page, Your Honor, I'm done. And finally, when Mr. Lefebvre tries to explain the inconsistencies about eastbound and westbound between the interview that he gave at the Lake Mirror Police Department and his trial testimony and the inconsistency in the 7-Eleven, well, he was just confused. Couldn't hear, just confused. Well, Mr. Lefebvre didn't talk about the biggest inconsistency in this case, Mr. Apperson's discussion or his description of the encounter during his interview with the Lake Mirror Police Department versus his testimony here. That's the biggest inconsistency. So if you want to call people liars, which Mr. Lefebvre did for an hour, and who's the biggest liar in this case about this crime, about May 11, 2015? Who's the biggest liar? I'm not going to answer that question because you know the answer to that question. What happened in this case is obvious. It's evident. On May 11th, they had an ongoing feud between the two. They had an ongoing feud, and on May 11th, that was it for Mr. Apperson. He was done with George Zimmerman, and their encounter, and it's amazing how it was a chance encounter with Mr. Apperson following him. But their encounter and the words exchanged did it for him. At that point, he said, I'm done with him. I'm taking care of it myself. And he took a shot at Mr. Apperson. That's what happened in this case. That's what the common sense tells you, and that's what the evidence supports. Thank you very much. Thank you.
Thank you, Mr. Stone. Ladies and gentlemen, we're going to go ahead and break for lunch. Instead of me reading you the jury instructions now, I think I hear your stomachs growling. So, going to give you the same instructions during the lunch. Please do not discuss the case amongst yourselves or with anyone else. Do not, if anybody tries to talk about the case in your presence, please tell them to stop, that you're on the jury. If they insist, please leave them at once and report the matter to a court deputy. Do not read or listen to any radio, television, or newspaper reports about the case. Do not read or create any emails, text messages, tweets, blogs, or social networking pages about the case. Do not use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology. And do not drive by any of the places described in the evidence for the purpose of doing an independent investigation. Do I have your assurances that you will abide by these instructions? I have a yes from everybody. With that, if you'll put your notepads down and follow Deputy Dempsey. T, just 1 second. Oh, I didn't tell him what time to be back.
No.
Could you just get T on the radio and tell him to hold up for a second? Don't bring him back in, Okay, so let's see. 2 o'clock, okay with everybody?
That's good.
Okay. Just tell him to stick his head in here and I'll tell him. Could you tell him to be back at 2? Okay, thank you. It's a good thing I realized it then. Okay, is there anything that we need to take up before we recess for lunch?
Not from the state, Your Honor.
Okay, thank you. We'll be in recess till 2 o'clock.